Hello and welcome to another episode of the LAN Party Lawyers podcast, the podcast intended for anyone interested in the e-gaming and esports industry. My name is Steven Blickensdorfer and I'm joined by my co-host Nick Brown. Through debate, discussion, and interviews, we tackle issues at the intersection of video games, law, and business. Remember, nothing we say on the podcast is legal advice. So today we are going to talk about an issue that's near and dear to the video game industry, intellectual property. We're talking about what is intellectual property, how to protect it, and lawsuits involving IP in the video game space. We're going to talk about these issues with a special guest, Gail Podolsky, who is a seasoned IP lawyer and chair of the Carlton Fields Technology Group in our Atlanta office. But before we get to the interview, Nick, why don't you start us off by explaining what do we mean when we talk about intellectual property?
So IP kind of falls into three big buckets for the purpose of our conversation today. Copyrights, trademarks, and patents. Putting on my law professor hat here. Copyrights really are designed to protect tangible expression, and it kind of addresses the difference between what is expression and what is ideas. And so your essays might have copyright, a recording of music might have copyright, or a video recording, perhaps, of somebody playing a video game. Trademarks, instead, are more associated with the idea of branding. Trademarks are a big deal for content creators. They want, understandably, to have a brand or a mark that lives out in the world and that belongs to them and that doesn't get misappropriated by other people, maybe operating under that name or using it for their benefit. And the third one is patents, which kind of they exist to protect useful inventions. And for our purposes today, patents do extend to protecting software and lines of code, which are, generally useful inventions.
I'm thinking of the guy, the caveman who's chiseling the wheel, right? I know we've all seen that TV commercial. Those are patents, right? 1-800-INVENT-THIS,
Well, I don't think the cavemen had patent protection.
Well, the caveman picture, I think, and that would be a copyrighted work, right? The trademark
presumably
would be like
it's fixed and original.
Yeah, and then the trademark would be 1-800 call me to patent this, whatever the slogan would be, and then
I don't think that's going to take off.
But then they protect patents. Interesting, huh? Has all of it wrapped in one little example right there. Anyway, protecting IP is a huge part of gaming. It affects everything from the games themselves to the people who are playing it. So why is intellectual property a big deal for the video game industry and content creators generally? Well, the failure to protect it can create legal exposure. It's like one of the most obvious areas where video games and the law collide in big ways. And so,
because naturally, if you're spending time and effort and resources and thought and hard work to create a product, you want there to be some kind of protection for that.
Right.
So that someone else can't just run off and take your completed work without having done any of the work themselves, claim it's theirs, and get the benefit that should have gone to you.
Exactly. So I'll give you an example. I've worked very hard on this dance move. I've been practicing in my closet for months, okay? And
I heard that about you.
And I unveiled it at a dance competition, at my local, dance competition scenery, and I found myself playing a game, and lo and behold, the dance move is in the game. It's one of the emotes. It's one of the character moves when, for those that don't know, you could, in today's games, many of the games, you could get or buy or obtain somehow different moves for your character. It kind of gives them personality, where you would do dance moves at the end of the game, or maybe when you're waiting, you hit a button and all of a sudden your character starts to dance. And so
or to trash talk after you.
Right. There's audio, there's different things, but the dancing in particular, and as it relates to one of the more popular games out there, Fortnight, included some iconic dance moves. I can't say included my dance move, Nick, in my example, but include things like the floss, arguably included some other dance moves, including, Rapper 2 Millie's Swipe It. It included one of the moves that I liked, which is the Scrubs dance, which was really cool.
Right.
The Carlton, another good one.
And there was a lawsuit about this recently, right? Epic was sued by, or a few lawsuits, bought by individuals that claimed to have the rights in those dance moves and claimed that Fortnite was, violating their copyright by using them and selling them for money. It's interesting the way it turned out. There was a Supreme Court United States decision that actually said that in order to bring the copyright claim on the dance, that the plaintiff, the party bringing the claim, had to actually own the copyright to the dance first. And so the lawsuits were dismissed, but we may see the lawsuits refiled if and when the plaintiffs are able to receive protected copyrights on the dances from the U.S. Copyright Office.
All right, so we're going to talk to Gail in a little bit about whether or not you could copyright a dance move, because I think that the whole debate is whether you can even do that.
But Steve is very, very interested in this
I am,
question.
because I just feel like that my dance move that I never announced, but if you could see me, you could see me dance it.
How convenient.
Is going to be found in a game sometime because it's just too good. And so the next example we have is actually, this one's fun. This is Booker T, the wrestler from days of yore. He was in the WCW with the New World Order, Sting, and Hulk Hogan when he was wearing the black and white. He actually had a character in the 90s as a pro wrestler, and he also created a comic book based on that character in 2015 called G.I. Bro. And so he sued Blizzard Activision, for its game Black Ops 4, in particular for allegedly adopting his character and creating this one in the game called David Prophet Wilkes.
Do they look the same? I didn't watch wrestling, so
right.
I don't know.
So yeah, if you looked at a picture of Booker T's character, you looked at this guy in the game, or you played this game, you would see a resemblance. The characters aren't the same, but the question is, could you be confused about it? Could a consumer be confused that instead of playing Prophet, they're actually playing G.I. Bro in Activision's game?
Which is interesting given the context that G.I. Bro seems pretty clearly to be based off of G.I. Joe, right? Different protected intellectual property.
The law doesn't appreciate ironies, Nick, so it's completely gone over their head.
Bird law in this country is just not governed by reason.
No, exactly.
So there's also trademark issues that are presented, with respect to games, and we're just going to touch on a couple of them. The big recent news is actually earlier this week, the band, or more accurately, the holding company that owns the band, Iron Maiden, epic, legendary metal band, filed a $2 million trademark lawsuit over a video game stated to come out later this year called Ion Maiden.
That's really similar.
Well, it's one letter different, but
we've said in the past podcasts, letters make the difference, Nick. Just one or two letters.
They sometimes they can. That's true. The complaint alleges that the makers of Ion Maiden misappropriated the Iron Maiden trademark, and it resulted in customer confusion, so that people probably are, under the mistaken belief that this is licensed or produced somehow by Iron Maiden. They also allege that the name and the merchandise that Ion Maiden uses is graphically similar to Iron Maiden, and in particular their Eddie character. They seek over $2 million in statutory damages, but they also demand that the company cancel the registration of the domain for the game, or actually transfer and give it over to the band Iron Maiden.
We're going to ask Gail this in a second, but I just imagine that it's shocking to us in terms of not always working with IP litigation, perhaps, but for someone that lives in the IP world all the time, this is probably not a shocking thing. But it is pretty incredible. Stop doing this and then give it to me, in a sense.
Right. And so the game is supposed to come out later this year. The lawsuit was only just filed, so we're going to have to watch to see what happens there. But it's a pretty interesting dispute nonetheless. The other interesting example we wanted to bring to your attention involves Rockstar's game Red Dead Redemption 2, which came out last year, I think October of 2018. It takes place, I think, at the late 1800s in America, and it involves, as characters, these Pinkerton agents who are, involved in the storyline. And after the game came out,
they're like bounty hunters, right?
Yeah, they're in the game. They're treated kind of like investigators, bounty hunters. It's not entirely clear, but they're kind of antagonists to the main characters that you get to play,
who are antagonists themselves.
Maybe.
I don't know, because they haven't ported it to the PC yet, Nick, so I haven't.
I guess it depends on your perspective.
I haven't played all these exclusives yet because I'm just sticking with my principles.
Well, you're missing out. It's a lot of fun. Anyways, so the Pinkerton agency turns out is a real agency that existed back then and exists now. It's like a 150-something-year-old entity, from what I understand. And they sent Rockstar and Take-Two, the creators of the game, a cease and desist letter. And when Rockstar got that, Rockstar and Take-Two filed a lawsuit, a declaratory action, claiming that the way that their game portrayed the Pinkerton name was actually fair use, despite some of the negative characterizations. We will, unfortunately, never know how that suit comes out because it was ultimately dropped in April of 2019. But it raises interesting questions about what, in a game that's semi-historically accurate, what type of representations are protected with respect to competing trademarks.
That's interesting. There's also IP rights to the games themselves. As you're developing the game and you're creating, sometimes they call it, like Blizzard recently announced, we're creating new IP, which is just another way of saying we got this other new game out that's unrelated to an older game that we're working on. So these large game publishers, such as Blizzard, like I just mentioned, they own these rights to these games and around the leagues which form around them. So Overwatch is a great example where the person who's basically giving the license to play or to the teams to organize these teams and create these business entities around the games, they have to buy the licenses from Activision Blizzard. So we're increasingly seeing the monetization of those rights. That's really what you see in this recent boom in investment into esports.
How much does it cost to buy an esports team like that?
Yeah, so in 2017, the price was $20 million to buy like an Overwatch team, and it doubled in 2018. So, Blizzard Activision is making some good money from selling the rights in these particular games. And so you can imagine that you're going to have values like that going forward. Maybe when Rocket League starts to form into something with now having gone over to Epic, maybe you'll see something like this going for one of the Rocket League teams.
It also comes up when they want to put on esports events, right? Because if you want to put on an event like a big competition for Rocket League or Fortnight or whatever, you need to get the rights to do that from the owners of that IP.
Yes, Nick, you're right. Actually, Epic recently sued organizers of an unofficial Fortnite event in Norwich. So you run it at your own risk, but these game publishers are going to enforce their rights to this IP, and that's something to consider when you're putting on events, particularly events. You want them to be official so that you don't run into those problems. So another way that this works in esports, which is pretty fascinating, is more in the traditional sense where you got sport games, and that's where the script is kind of flipped. So you have take a league like the NFL licensing their IP to Electronic Arts for Madden, for instance.
The annual Madden football franchise.
Right. So you can see the rights basically originating from the National Football League and then trickling down from there. So it's just another way of where's the source of the intellectual property is really the starting point, and then from there you can kind of figure out, all right, well, if you have to get rights to do something with respect to that IP, who would you be going and asking those questions and getting that permission?
And media rights come into play too, right?
Yeah.
Just displaying the content, having distribution deals, any kind of licensing issues for marketing or merchandise or things.
I think that media rights is going to be the next big thing, and I'm not alone in my estimation there, because take Twitch, which just recently announced they're exploring plans to do a pay-per-view style viewing of certain competitions. If that succeeds,
subscriber only.
Right. Think about it. Right now, everything's free. You go on any mixer, you go on Twitch, whatever you're using, you can access and watch any competition or event.
Right. You can pay extra to get additional features like emotes and chat privileges and things. Right. But the basic functionality is like just standard band TV.
Right. So basically, media rights boils down to the right to display content, and at some point, you can expect that companies are going to monetize that as people would pay to see a certain event. And Goldman Sachs, relying on their report from a couple of months ago, they expect that figure to climb. So currently in this Goldman Sachs report, media rights account for 14% of revenue. They expect that figure to climb up to 40% by 2022. So
That's almost triple. That's huge.
So the last thing, Nick, I think we should go into is patents real quick, because, in this industry, you don't have to go into details, but esports and video games, I think the potential for patent protection, or the need for patent protection is real.
Yeah.
And the potential for using new and innovative technology is unlike almost any other industry.
Yeah, and with emerging industries within the tech industry, right? You're gonna see more and more new technology as people come up with modern solutions in these technologically advanced areas with a bunch of technologically savvy users. We're not going to go into a great deal about this in the podcast today, but we just want to note that we're seeing a bunch of significant patents be applied for and granted with respect to esports and gaming in general. From things you might expect, like video data management, like for game streams, like how they get the video from the competitor's computer all the way to your Twitch screen or perhaps your mobile phone. There's also cross-platform patent opportunities involving, what if you want to hold a tournament and you got 10 people playing on Xbox and 10 people playing on PlayStation, and they're really comfortable with their own, little ecosystem, but you want to be able to play them together. It takes a technological solution to actually have a fair competition. Esports event platforms are another example, and even something that surprised me, which was fairness algorithms. Algorithms designed to make sure that the games are being played fairly. Which would really impress me, which is probably why they got a patent for it.
Isn't that like the Punk Buster? It kind of reminds me of that, the old school, take the cheaters offline kind of.
I do, and I remember I was never a cheater, but I had more trouble with that than any of the actual software. They always seemed to think that I was cheating.
Mm-hmm.
I assume because, I was just doing such a good job.
I assume they were right. So I think it's time to bring Gail in here and to talk to her a little bit about some of these things. So Gail, thank you again for joining us on the podcast. We really appreciate your time and for kind of cracking an egg of knowledge on this situation here. So first let's do a little warm-up question. Why don't you tell us whether you're a console or PC player and the last game you've invested any significant time in?
Well, first of all, I want to thank you again for bringing me on. And for two non-IP lawyers, you guys did a great job at explaining IP and kind of the issues that are going on in the gaming industry.
Hey.
As for me personally, I'm a console player. And, I think it comes back to, and I'm going to date myself here, playing the Commodore and Atari, followed by Nintendo.
Street cred.
Grew up playing Tecmo Bowl, so now I've moved on and matured. So, Maiden is certainly one of my favorite go-tos. But if it's not going to be a sports game, then my heart will always be with Resident Evil.
Nice. Very nice.
They had a recent remake come out. I never really got into the Resident Evil series, but I know the fans of it were really happy with the recent one. You may want to check that out.
I was always too scared. It's too scary for me.
Well, if you ever find me at a Dave & Buster's, you're going to know where I am.
Okay, Gail, so maybe a good place to start would be to kind of talk about some of your feedback on some of these cool cases we were talking about earlier. And the first one I know is near and dear to Steve's heart, which is the Fortnight dance copyright case. Do you think that is, a reasonable way for that to turn out? Should they have to get the copyright before they can bring the suit? And what do you think is going to happen there?
Well, unfortunately, Steve, I have to say that your super fantastic dance moves are probably not protectable. But I would like to see them someday. In terms of
be careful what you wish.
Yeah,
for.
it's like the Napoleon dance. So
excellent.
Napoleon Dynamite dance.
So, in terms of the Supreme Court and the decision that basically says you have to register your copyright before you can go into court, I think that's the right decision. They're similar to patents. You have to have an issued patent before you can sue for patent infringement. Someone shouldn't be able to just go into court claiming copyright infringement without having the registration. But even if we take that prerequisite out, looking at the 50,000 foot level, do they actually have copyright protection in these dance moves. And I think at the end of the day, it's going to be difficult. Since they filed suit, the Copyright Office, the United States Copyright Office, actually rejected the applications.
So what if my move is my dance move is really technical? I mean, I'd be hard pressed to see you guys be able to copy my moves. Does that increase the chances that I'll get some copyright protection?
So the technical aspects to your dance is typically not what is looked at. It's mostly the length. So if you, for example, an entire ballet.
It's also really long. My dance move is like minutes.
Steve's move clocks in about 90 minutes.
How am I
Well,
doing?
now we're getting more into a performance right. So have
Okay.
you publicly performed it?
Now
and
we're
has
getting
it been
somewhere.
recorded?
All right.
And if you've met those things, and again, it's your original creation, you didn't take it from other people, and you've
Scouts honor.
actually performed it in front of people, then it's a closer call. But, what we're dealing with here, for example, in the Carlton dance, it's a very short move. And,
But it's fierce.
yeah, I do love the Carlton dance. I'm not going to lie. I was a Fresh Prince of Bel-Air fan.
Yep.
Born in West Philadelphia.
Which is funny. I'm not sure a lot of the current Fortnite demographic would know specifically the character that dance derives from.
But they can floss up and down, Nick. And I've tried it. My wife hates it when I try it, but it is what it is. So let's move on to a different lawsuit, if I may. The GI Bro lawsuit. So again, this is the African American character in the game with the combat gear, kind of looking like another artist's work, putting away his name, GI Bro. But what do you think of that one?
Well, first I want to start off with I'm really disappointed you didn't mention Ric Flair in your list of wrestlers. I was actually on a plane recently where he was sitting in first class, and I kind of geeked out.
Oh, man.
But, in terms of the lawsuit, I think he's going to have a hard time. The idea of someone dressed up in military garb carrying a gun, that is not really an original work of authorship. And there's going to be a really strong First Amendment defense there that basically says, you have some artistic freedoms, and how else can you articulate or show someone in the military without having them in military garb carrying a gun?
So, one thing that strikes me a little bit different about this from the Fortnite one is, a dance is a dance. Does this guy have a better claim by virtue of the fact that he had a comic book, like an actual fixed piece of media containing his character that he's claiming as copyright? Does he have a better position than someone who just says, those moves are mine?
If there was more unique criteria to his character, I think the fact that he would have a comic book would certainly help. But again, we're talking about a real general character, similar to how they don't protect magicians or knights in video games. Could you imagine if someone
that's Steve's other side hustle down the drain, too.
Seriously, shooting them down one by one.
So, yeah, I have to say, I understand he's probably angry about this, but I'm not sure that his claim is, at the end of the day, is a very strong one.
So is that, you mentioned the defense there, is that like a fair use defense? And what would that look like?
So the First Amendment defense is slightly different than the fair use defense. The First Amendment defense is basically there's artistic relevance to the underlying work, and you're not misleading anyone. So the video game is not saying or referring to the wrestler. And if the users of the game do not believe that this is the wrestler, there's not what we call instances of confusion, then it's going to be really hard to convince a court or a jury that there's some sort of infringement.
Right. So maybe the analysis would change if this character in the comic book had a distinct move that this guy in the video game also did. Maybe that would change things up. I'm just trying to give Booker T a chance here. You're shooting them all down. All right, let's move on to Iron Maiden. Eddie, great band, but did they make the right move here?
Absolutely.
And by the way, there are no opinions here. We know that we're not, opining as to anything. We're just kind of, talking about these cases. But yeah, so what did you think of this one?
As a brand owner, that is the right strategic move to make. They have Iron Maiden has trademark registrations that cover Ion's goods and services that they are currently doing. The names are visually similar. I think someone could be confused. I believe in the pleadings they indicated that there were already instances of actual consumer confusion where they were affiliating or associating the game and Ion with Iron Maiden, and that's what trademark law
Can't
is all about.
Can't imagine why. What's interesting here to me, one piece among all the other parts of the case is Iron Maiden actually had a video game previously. It was called Legacy of the Beast. So that makes it a little bit easier for them to argue that there's possible confusion because it's not like a completely new space or a completely new expression of the band, right? Because they actually, having made a video game, someone might think that this, is just another one.
Absolutely.
What kind of tips would you give? And I know that we're going to do our takeaways later, but like if you were going to create a game, how close would you get to something like this? Where's the line, I guess, where you've got this general, I don't know. I guess what would be your, rule of thumb when it comes to building IP around something that might touch other IP? Like run for the hills? Like you want to stay as far away as it is possible, or do you have any takeaways? Is it just too gray? I don't know.
So I'm going to give you the typical lawyer advice that I'm sure you have given before is it depends. It depends on what we're talking about here. Is it trademark law, copyrights, or patents that are being implicated? So that's one thing that we look at. Most of what we've been talking about today is either in the copyright and the trademark context. With trademark, you don't want to pick a name, a domain, or characters that are similar to something that's already out there, especially something that's famous, especially like Iron Maiden.
Right.
Maybe don't take a 40-year brand and change one letter.
That's good advice, Nick.
Good takeaway for this one.
We're not taking sides. I was just using that as a hypothetical.
Total hypothetical.
What about if you're approached by a client who has been around, the landscape for 140 years, and they're saying, listen, I found my great-great-great-grandfather's company's name referenced in this game.
And he was dancing.
And he was dancing the floss in the hills of Montana. I don't know where Red Dead is because, again, until they port it to PC, I won't know. But the Red Dead trademark lawsuit, how does that look?
So you're combining all of the cases we discussed into one. It sounds like a law school exam.
Yes or no, Gail?
Did the helicopter explode too and fall on my grandmother? So, with the Pinkerton case, it's... I can see why the lawsuit went the way it did in the sense that there was a declaratory judgment action filed and that the Pinkerton was upset. They sent a cease and desist letter, and in response, the folks at the gaming company, they filed a declaratory judgment action basically saying, court, please declare our rights that we are not infringing. And
so the suit was brought by the people claimed to have done the wrong instead of the typical way where someone sues and the defendant is the one alleged to have done the wrongdoing.
Yeah, it's a nice little nuance in the IP world that you can do that. Once someone sends a cease and desist letter, it creates the buzzwords are actual case or controversy. And once that happens, then someone can file, there's a statute that allows you to go into court first, so you could pick where you want to sue and claim and ask the court to make the decision. And in this case, I think that Pinkerton has a tough or had a tough road to hoe, and maybe that's why the case resolved itself. And the reason for it, I mentioned before the First Amendment defense. That's a really great defense for to attack Pinkerton's claim of infringement. I mean, here they're trying to be historically accurate. And how else can you be historically accurate but to refer to, the actual company that was going out and catching the bad guys.
But on the other hand, if you're presenting it as historically accurate and you make them seem, very distasteful or have them doing, inappropriate acts that might lead, to type of a defamation claim, where's the line on that? Can you at the same time, take protection in the fact that you're saying, oh, well, it's historically accurate, we weren't going to make up a new entity. But then at the same time, also say, oh, well, it's just fiction, right? They didn't really do all this bad stuff. That that's just part of our story.
This is your second question on the law school exam, Gail.
So, I think in that case, it's going to be a very fact-intensive inquiry into, what is really quote-unquote defamatory, if it is defamatory. I would argue that it's lessening or devaluing the Pinkerton brand, which would potentially rise to what's called a trademark dilution claim. So their trademark becomes less... it's devalued because arguably they're potentially making fun of Pinkerton. On the other side, flip the coin. The argument in response is, well, it's parody. And that gets into the whole Two Live Crew analysis on what is a parody. Is there a social commentary aspect to it? And is it clearly poking fun? Is it a social critique? So that would all need to be, fleshed out in the litigation, which, again, the case was dismissed. So unfortunately, we don't get to see how the court would decide that. But it's certainly it was an interesting set of facts. And I would have liked to have seen how it would have ended up.
So I want to switch gears real quick to talk about some hot button topics in IP and video games today. And I'm really looking at like the Marshmello concert. That, for those that don't know, Marshmello's a rising star in the EDM, the electronic dance music arena, and he had a concert earlier this year in Fortnight that was attended by 10 million spectators, which is
the concert was completely contained and held and presented within the game of Fortnite.
Right. It was,
to our knowledge, it's the first time something like this has ever happened. Certainly not to this scale.
It was the biggest event online, and it was 3 times. I love this stat. It was 3 times bigger than the best well-attended event concert in the world. So, thinking, to me, that just screams like a bunch of new IP issues and new fact patterns that we haven't conceived of before. But I would imagine, maybe it's simpler. Maybe I'm overthinking it, because if you were Marshmello before you started that concert, I'd imagine there'd be a contract in place where you'd say, okay, this music that I'm about to play, these are the rights to it that you may or may not have to play it. And then, if we do a live, I can imagine like a live from Fortnite CD, that Marshmello has of what he played. I don't know. Do you have like digital crowds screaming in the background? It's kind of crazy, but I imagine stuff like that's going to happen, where IP is going to create with an IP, and there's going to be so many stakeholders to that IP that you got to have a contract, right, Gail, to set out the rules with respect to who can do what with it.
Well, if I was Marshmello's counsel, I would certainly tell him that, yes, it does make sense, and I highly recommend that you have a contract. But another interesting issue to this is, you have so many viewers that are experiencing Marshmello's music that he would have never had, except for him being on Fortnite, is who should be paying for whose services? Should Fortnite be paying for Marshmello? Or in turn, I could argue that Marshmello should be paying Fortnite for the exposure.
Who are you representing here, Gail?
That's a great point. It's mutually beneficial, right? And the question is, who's getting more out of it? And I imagine both sides would say you are.
I would imagine, Fortnite could get any artist it probably wanted after this, and people would be lining up the door.
In that regard, the famous, well-known band Weezer released an album in Fortnite around the same time. I think it was a little after the Marshmello concert, but I could be wrong about that. But they had a whole island in the game dedicated to their new album that they released for free, at least at the time, through jukeboxes in the game. And I understand that was pretty well attended too. And so that that supports what you were just saying, Gail. Sorry to interrupt, but I wanted to throw that out there.
Yeah, and then you take it another step further, and you have Coachella where they're doing live feeds with drones, and now you have artists that are performing live in video games like Fortnite. What is going to be the future of concerts?
Right.
Are people really going to go to venues and spend all this money, or are they just going to turn on their console?
You can't mosh on a PlayStation, though.
That's
Let's
true.
Throw that out there.
That's true.
I feel like you could in your living room.
I like your attitude.
Gail, that's going to start looking like my dance, unfortunately. So you can't do that.
Be careful.
Yeah, be careful.
I'll show you my mash.
I'm gonna send a takedown request. I want to switch before we leave Fortnite altogether. I wanted to mention things that we're seeing in games and from what I understand to be pretty common, fan content policies. So when you sign up to create an account to go and play Fortnite, you have to agree to certain things, their terms of service, privacy policy, and a fan content policy, among other things. And that policy will say, we appreciate all of our, excited fans that want to, make a Fortnite T-shirt or banners or digital, IP, but you can't monetize it. You can't commercialize it. I just wanted to get your take on stuff like that. Is that something common or maybe unique to video games, or are they in other industries as well?
Yeah, we've actually been seeing this for a really long time. With the birth of the internet, and no, I'm really dating myself. We have terms of use policies, and you have folks that have message boards. You have contests that are conducted solely online where people are putting up videos, or they're making T-shirts, and the contest rules or even the terms of use of the website will say, we own everything you send to us. You have to abide by all of these rules. You can't bully people. You can't put up defamatory conduct. Even if the court finds that we didn't own this stuff, that you didn't give it to us, then we have a assignment in perpetuity to use it however we want. We don't have to pay you a dime. So you're basically, anytime you give up something either through the game or online, you are, for the most part, generally speaking, if they're drafted properly, are assigning and giving away all of your rights to whatever you've posted or,
right.
Or content you've created. So it's a little scary for the gamer, and something certainly to be aware of.
That means that Steve can't sell all of his finely crafted Battletoads crafts that he has been putting together over the last 20 years.
Cat's out the bag now, Nick. Thanks. Appreciate it. And what's also neat about Fortnite's fan policy is they have a disclaimer in there. It says, if you send us your content, we will destroy it. So don't bother. I love that. So, but I mean, where's the line, Gail, with if I wanted to take the little llama in Fortnite and create an art out of it, right? Like I wanted to paint something. Is that considered fan content? What if I'm an artist and I actually, I have people who pay for my art? Can I do that? Can I paint the llama in abstract expressionist painting?
So the artist would say that this is what's called a derivative use. So you are creating new copyrighted content by adding your original authorship to it, so that you wouldn't be infringing. However, Fortnite and the owners of that content may take a different approach, especially with these fan content rules. They could construe, fan content rules are arguably a binding enforceable contract. So as, being allowed to play the game, you are agreeing to these terms. And so if the terms prevent you from commercializing anything with the game and selling it, then, you might have some liability there.
Geez, Gail, Nick and I are very fortunate that you're part of the team, because not very many people have the resource to be able to ask you these challenging questions. I don't know how many types of law school exam questions we've asked you today, but I tried to stump you more than once.
Can you paint the llama was going to do it,
right?
But,
it was my
answer to that too.
Last ditch effort. But for those that don't have Gail on speed dial, what are some of the takeaways or resources that are available for? I don't know. There's many players involved. You have the game developers, you have the content creators, who I think are maybe the most vulnerable, because they might not know where the lines are, and they don't want to get a takedown request on YouTube or whatever else they're putting their content. So do you have any tips as we wrap up?
Yeah, I do have a few. So first, a little shameless plug for our firm. We do have some great free content that would be very beneficial, I think, for both gamers as well as content creators, developers. We have a website. It's called launchtothrive.com, and it provides free legal resources. You can get an IP assignment, trademark assignment, a model release. So if you're using people's images or photographs, as well as some other basic incorporation documents. So if you're going to start a company or a joint venture with some developers and content creators, and so that's a really good reference. Also, I have to say the U.S. government does a really good job at explaining some of these issues that we've talked about today. So for copyright, the website's copyright.gov. And then for trademark and patent, it's uspto.com, and that stands for United States Patent and Trademark Office. So those are two free resources that also provide some great content.
Great.
That's great. Thank you. All right, well, I think that wraps up our show for today, but we do want to take a moment and extend a sincere thank you to Gail Podolsky for coming and helping us out here.
Thank you,
not
Gail.
only are you sharing your time with us, but your very helpful expertise, even though it might end up now in more of Steve's dance maneuvers, but we will weather the storm over here.
I'm dancing right now, Nick.
And I love it.
Well, you viewers, listeners can connect with us on social media, on Instagram, or through our webpage, landpartylawyers.com. Be sure to check out other episodes from Season 1 of the podcast. And unless you have anything else, Nick, I think we're done here.
That's all I got. Game on.
Game on.
You've been listening to the LAN Party Lawyers podcast series with Steve Blickensderfer and Nick Brown. To learn more about our e-gaming and esports practice, visit carltonfields.com. This podcast is intended for general information and educational purposes only and should not be relied on as if it were advice about a particular fact situation. The distribution of this podcast is not intended to create, and receipt of it does not constitute an attorney-client relationship with Carlton Fields. Thanks for listening.